Good morning, I'm Diane Smith, and here's the latest from the state capitol on this Wednesday morning. The 2011 legislative session ends tonight at midnight. No, you're not hearing cheering behind me, really. That's 15 hours from now. Yesterday, some long debates played out in the House and the Senate. The longest was in the Senate with the final budget implementer dealing with revenue, HB 6652, which passed in the House early Tuesday morning and was debated for nearly 9 hours in the Senate yesterday. It includes revenue portions of the budget and the state employees union concession agreement, which has yet to be ratified. And the nonpartisan Office of Fiscal Analysis has said it cannot confirm all the savings in the agreement at this time.
Lastly, Madam President, we tend to average deficiencies of about $100 million. For the life of me, I don't know how we're going to stay under the constitutional spending cap when we're as close as we are, given our history of lapses and deficiencies. I don't know how we're going to do that. And that's why I stand in opposition to this. We are being asked to vote on savings which our own fiscal analysis has said they don't have any data. Numbers are simply just negotiated and made up without data, and in many ways are unachievable. We're being asked to vote on savings which OFA would said, if affected, would be bottom line lapses, even though there are already significant bottom line lapses built in to the budget. And I believe those numbers will be double counted and not achieved as well. There was this sense of excitement, I think, that came out of the administration. I don't know the exact quote, but it was something along the lines of, "We've passed a budget earlier than ever before in the state of Connecticut." Well, no, we didn't. No, we didn't. If you want to say passing a budget that's $2 billion short is passing a budget, you can say that. Not for me, it isn't. If you want to say passing a budget with $1.6 billion in savings when we don't know if that's going to be ratified by the unions is passing a budget, you could say it, but it isn't for this senator.
This budget that was proposed back in February by a courageous governor has been analyzed by this legislature. I would say it's been improved by Democrats and Republicans. There have been suggestions along the way. We have not implemented this budget without very significant analysis and many meaningful changes. And that's the way it should be. It's not a rubber stamp process. It's a collaborative process. And we have strengthened this package with Republican ideas and Democratic ideas. So what we wind up with today is a budget that meets the tough challenges that we face in the state of Connecticut and that every other state faces across this country.
Nearly 7 hours into the debate, a series of Republican amendments were introduced and voted down before it finally passed the Senate by a vote of 20 to 16. The bill now goes to Governor Malloy for his signature. Also yesterday, a 4-hour debate played out in the House regarding SB 1243, a revised version of Senate Bill 1, creating the new Department of Energy and Environmental Protection and planning for Connecticut's energy future. It ended up passing the House by a vote of 139 to 8. It now heads to the governor. And then early this morning, the House also passed SB 1152. That's the Yukon Health Center bill creating Governor Malloy's bioscience initiative. It passed by a vote of 97 to 45. Having already passed the Senate, it now goes to Governor Malloy for his signature. And for nearly 5 hours yesterday, the House debated SB 1014, which would decriminalize the possession and use of less than half an ounce of marijuana, making that penalty into an infraction. Here's a little bit of that debate.
Currently, Mr. Speaker, according to the reports that have been provided, there are 13 states that address small amounts of possession of small amounts of marijuana in a non-criminal setting. And what this, it would probably help if I laid out what the current law is. Currently, possession of less than 4 ounces of marijuana for a first offense is punishable by up to 1 year in jail. It is an A misdemeanor. Those convicted of a second offense, Mr. Speaker, can be found guilty of a felony that would be punishable up to 5 years in jail. Now, I think it's acknowledged that many people do not get, at least initially, convicted of drug offenses, or at least in terms of small amounts of marijuana. But those are our current penalties, and that is where the law currently stands. So it's anything less than 4 ounces of a cannabis-type substance.
It's hard for me, looking at the federal policy, knowing how many children this affects and potentially could affect, knowing that many people that are in our mental health institutions across the state and across the country started out with their first puff on a marijuana joint, knowing that many companies, if you smoke drugs, you're fired, and believing in my heart that we have to have a very strong stance on drugs, and that requires us saying no to drugs. If you do drugs, you have the potential to go to jail if you're 12 to 20 years old. Just the threat deters kids from doing drugs.
What we're saying to the youth of our state is it's not a crime anymore. And they're going to take advantage of that because they don't realize how dangerous marijuana can be. I understand what the intent of the bill is. I'm not saying, I understand what the intent of the bill is, but it's not going to help our youth. Our youth are going to take this wrong.
The intuitive thing to think is that if you want to stop something, increase the penalty, and that will cause fewer people to do it. Sometimes that works as a policy. But I think in everything that we've learned over the years in terms of trying to prevent drug use, particularly among our young people, tougher penalties don't necessarily lead to lower use. I want to save those same kids that the minority leader is referring to. But I think this policy that we're adopting today is the way to do it.
SB 1014, as amended in the Senate, passed the House by a vote of 90 to 57. This bill is also on its way to the governor's desk. He reiterated in a statement yesterday that he will sign it. Then, in an unexpected move, the Senate amended a bill, SB 912, concerning the flavoring agents for prescription drugs, adding a study of implementing a medical marijuana program in Connecticut, something Representative Penny Bacchiacchi attempted to do yesterday with the bill dealing with the decriminalization of marijuana, but was not successful at that juncture. Joining me now to talk about this and other issues that relate to the police and to the judiciary is Mike Lawlor, who is the longtime head of the Judiciary Committee, served for 24 years as a lawmaker from East Haven, and is now working for the Malloy administration as the Undersecretary for Criminal Justice Policy and Planning at the Office of Policy and Management. And our other guest today is Chief Anthony Salvatore, the Chief of the Cromwell Police and the Legislative Liaison of the Connecticut Police Chiefs Association. Thank you so much for being with us here, both of you, this morning. I appreciate it. Mike, I think the first thing that I thought about was how many times a bill like this had come up while you were a legislator, did not pass, and now you're not in the legislature anymore, and it finally goes through. And I was just thinking on a personal level, what did that feel like?
Well, it's the happy last day of the session, Diane.
Thank you.
It's,
Thank you.
And I think through CTN, people get to watch how this unfolds in the last 72 hours, and it's really a sight to behold. And you've mentioned just now how many things start transpiring in just the last few hours. And for me, as a former legislator, having been on the inside watching these things take place, I kind of have a clear understanding of what the process is, but if looking at it from the outside, I think it could be very confusing. For me, it was very satisfying earlier this year that Governor Malloy proposed some bills that have been considered by the legislature in recent years, and to see them actually get through the process is very important because, as Governor Malloy will say, he wants to focus our criminal justice system on violent and serious offenders and have a lesser priority for some of these nonviolent minor offenses so that we can shift our resources dealing with violence, domestic violence, things like that.
Chief, when you testified, you talked about the fact that the police chiefs also don't want to clog up the courts and the prisons with small crimes or nonviolent crimes, but you had a slightly different take on the whole decriminalization thing.
Well, first of all, first and foremost, the legislature sets the policies, we follow it.
Right.
And along with my partner, Chief Jim Strelacci out of West Hartford, over the years, we attempt to guide the legislature of what we feel as police professionals is the right way to approach certain pieces of legislation. And we've been very fortunate. We've had a really good working relationship. Our main concern when we testified was not necessarily that we were opposed to what the proposal was with regards to a criminal violation versus an infraction, but rather that our officers would lose the right, if we had probable cause, to search the individual and or the motor vehicle operator's compartment. As it proved out after we did our testimony, Massachusetts had some problems with regards to that. We talked to certain people up here at the legislature to reiterate that we didn't want to lose that ability. We were assured both in the House and the Senate that we wouldn't lose that right, and as a result, the majority of our concerns have been addressed. Now it's going to be training and implementation of the policies and procedures, how we're going to make this work now.
And Chief, that was my next question, because there were a lot of questions about it yesterday during the debate, which is this is a very small amount of marijuana, or at least a small amount. Are your guys going to have to carry a scale in the car to see how much marijuana to determine on the spot what type of a penalty there is, or if it's an infraction or what it is? I mean, how do you actually go about implementing this?
Well, certainly some of it based on sight of let's say a roach, you're going to know right away that it's less. But there will be times when the officers will not, and I think it's going to be on a case-by-case basis with regards to department by department how they're going to proceed, whether they may issue scales, and they have to be certified, by the way, to each and every officer, or perhaps their supervisors, or perhaps detectives. Because in my opinion, the intent was not to arrest these people, bring them back to the station. As much as possible, you want to do it out in the field, so we're going to have to look at it, make sure we're able to make it work, and make it work out in the field. So those are some of the things that, as police chiefs, we will be discussing, probably with Post also, to make sure that in training these sorts of issues are addressed. So those are the things that we are looking at, and I think it's going to be dealt with on a department-by-department basis.
Can I just add something to that, Diane, because this is really important. We spent meaning the administration, a lot of time talking to legislators about this very issue, and now that the bill is going to become law, we'll be out meeting with police chiefs and others to deal with the training. But police officers don't have to carry scales to enforce this. Police officers have a lot of discretion. All of our drug laws now contain some differentiation based on weight. So, for example, the current law is less than 4 ounces of marijuana has one penalty, more than 4 ounces has another penalty. With cocaine, it's the same kind of distinction. And so police officers make their decisions based on probable cause. So if a police officer thinks it looks like more than a half an ounce, that's certainly probable cause. When it gets to court, then the court will deal with technically how much does it actually weigh. But on the crime scene, that's up to the discretion of the police officer.
Can you explain what the penalties will become under the new law now?
Sure. So for possession of less than a half an ounce of marijuana, or
not half an ounce and less, but less than half an ounce.
Yeah, less than half an ounce.
Yeah.
Although that may be a distinction without a difference. Who knows? It'd be kind of hard to hit it exactly on the head. And also for possession of drug paraphernalia related to less than half an ounce of marijuana. So, for example, the marijuana is the marijuana, but the rolling papers or the baggie it's contained in, those are technically paraphernalia, and that's against the law to possess too. So the penalty for both of those things has been lowered to a to a violation, and which means that the most you'll have to pay is a fine, unless you're under 21 years of age, in which case you'll pay the fine plus you'll lose your license for 60 days, which is the identical penalty as underage possession of alcohol.
Okay.
And I would argue, having been a teenager once myself many years ago, but I think for a teenager, the prospect of losing your license for 60 days is much worse than what the current law provides for possession of marijuana, which is you go to a couple hours of community service and they dismiss the charges altogether. For kids that are juveniles, under the age of 18, they're going to be mandatorily referred to juvenile court. So that won't be a discretionary decision, and the court can get involved and pursue